This is a lecture on crimes. It is the analysis of the crimes question, which was on the February 2004 bar exam. It is a crossover of evidence and crimes. So it's really a crimes, it's mostly crimes, but it is a crimes evidence crossover question. I will assume that you have read the question, that you are totally familiar with the facts. If you're not, please stop the video and read the question. It would be better if you also did your own analysis so that you can then have done the analysis and compare what you're doing against this lecture. In this problem, you recall that someone has robbed a bank using a shotgun, and the police received an anonymous tip that a person was seen who fit the description of the person who had robbed the bank carrying a sawed-off shotgun at a certain location downtown about an hour and a half after the bank robbery. A police officer who was in that vicinity learned about the bank robbery and the description of the person who committed the bank robbery, and this police officer saw Dave in this downtown area. And Dave fit the description fairly well. It wasn't a real great description, but it was a fairly good description. It says says an hour and a half later, the police received a telephone call from an anonymous caller who described a man standing at a particular corner in the downtown business district and said the man was carrying a sawed-off shotgun in a briefcase. And that's when, within minutes, a police officer who had been informed of the robbery and the telephone call observed Dave holding a briefcase at that location. Dave fit the description given by the anonymous caller. And so now we take it from there. And you know the rest of the facts. The officer approached Dave with his revolver drawn, pointed to the ground, and explained the reason for his approach, and handcuffed Dave, opened the briefcase, and the briefcase contained only the marked money taken in the bank robbery. And the officer said to Dave, quote, "I know you're the one who robbed the bank. Where is the shotgun?" Close quote. Dave then pointed to the nearby trash container in which he had concealed the shotgun, saying, quote, "I knew all along that I'd be caught." Okay, so that amounts to a confession. And obviously we're going to have some problems with that confession. Dave was charged with a robbery. He's chosen not to testify at all at trial, except he wants to be allowed to read a newspaper article selected by the judge without being sworn as a witness or subject to cross-examination in order to demonstrate that he has no accent. He is also moved to exclude from evidence the money found in the briefcase and his statement to the police officer and the shotgun. And how should the court rule on all that? Well, the first question is, how should the court rule on the reading of the newspaper article? This is obviously an evidence question, and so the question is, should this evidence be admitted? Should we allow Dave to read the newspaper article to demonstrate that he has no accent? Well, please be careful here, because the question is, should the evidence be admitted? The question is not how much is the jury going to believe that this person does not have an accent because they read the newspaper without an accent. I mean, the person may have faked the accent when they were robbing the bank. And so to now not have an accent, how convincing is that going to be to the jury? Answer is probably not very convincing. But in any case, the question is not is the jury convinced? The question is, should you allow him to read it? Is the evidence admissible? The rule, remember, throughout these problems, that the basic strategy always is rule application, rule application. Anything other than rule application will diminish the number of points that you're going to get. You have to know the rule in order to do it that way, but that's what the bar examiners are testing for. If you make up a phony rule, the graders will instantly know that you don't know the real rule and you've made up something phony. So the question is, what is the rule for admitting evidence? And the answer is that evidence is admissible if you meet three requirements. The evidence is relevant, has a proper foundation, and there are no exclusions. This is the rule for admitting evidence. Relevant. What do we mean by the evidence must be relevant? Well, here it's important for you to understand how the purpose of evidence at a trial. When you go to trial, you are trying to persuade the jury that each element of the cause of action has been satisfied. And that's all you're trying to do. Everything that you do at trial is aimed at trying to convince the jury that each of the elements of the cause of action has been satisfied if you are the plaintiff. And of course, if the defendant has some defense, you try to defeat the defense. But forgetting about that for the moment, the basic idea, if you're a plaintiff, is to convince the jury that every element of the cause of action has been satisfied. Now, what you need to know and what needs to be clear to you is that you do not present evidence on an element. Okay? Once again, you do not present evidence on an element. You don't prove elements, not really, at a trial. What you do at a trial is you try to prove facts. You try to prove facts. And you try to select the facts that you're going to prove in such a way that if the jury believes that these facts are true, they will then believe on their own that this element has been satisfied. So it's really a two-step process. For example, suppose there is a trial for burglary. We all know that burglary is the breaking and entering nighttime dwelling house of another with intent to commit a felony therein. And you are the prosecuting attorney, and you're working on the element breaking. Was there a breaking? Well, at some point the jury is going to be told what a breaking is, increasing the size of the opening at all. And they'll be told what an entry is. And now you put on evidence that, you put on, for example, the evidence might be in the form of testimony. It might be in the form of photographs. It might be in the form of objects. But you put on evidence that there's a window at this house that has been broken, and there's glass on the floor just inside of that window, and the window is partly raised up, and there's a footprint in the dirt outside the window, and some of that dirt is inside the house, inside the window, and there's a hammer on the floor just underneath the window, and there's some blood, a little bit of blood on the glass down there below the window. Now these are all facts. And you try to establish these facts, prove these facts by putting on testimony of people who saw it. Maybe you'll put on photographs of pictures that you made of this. Maybe you'll bring some of the glass itself into the court. And so you try to prove these facts that I just told you. And if the jury believes that those facts are true, the jury is almost sure to believe that there was a breaking and there was an entry right there at that location. But you prove facts from which you hope that the jury will conclude that if these facts are true, then this element has been satisfied. And so at the trial, your evidence is not directly aimed at an element, it's aimed at proving facts. But you choose the facts for the reasons that I mentioned. The facts that you choose are called facts of consequence. They are facts of consequence if these facts matter in the sense that they will helpfully convince a jury that an element has been satisfied. Now, so evidence is relevant. If you look at FRE 401, for example, or the California Rules of Evidence, evidence is relevant if it has some tendency to prove or disprove for that matter, to prove or disprove a fact of consequence. Any logical tendency to prove a fact of consequence. And you understand what a fact of consequence is now. It's a fact that matters for the reasons we just talked about. Now, in our case, the question is the testimony of Dave relevant? Well, first of all, Dave's testimony is called demonstrative evidence. Now, the type of evidence that he wants to offer is called demonstrative evidence. You know there are various kinds of evidence. There's testimony, that's evidence. There's documents, there's objects, opinions, scientific evidence. And here, demonstrative evidence is evidence where you want to demonstrate something before the jury, and you demonstrate this, but the thing that you demonstrate, whatever demonstrative evidence you offer, you must do it in a way that the demonstration is reasonably similar to the actual facts that you want the jury to believe. If I want to convince the jury that a bullet would ricochet in a certain way, and if I create a setting where the jury can watch the bullet ricochet, well, the setting that I create needs to be similar to the one where I'm claiming the bullet did ricochet. So that would be demonstrative evidence. In our case, Dave wants to show that he has no accent, and he wants to simply demonstrate that. And of course, again, the jury might not believe that he's not the person because of that, but he should have a right to demonstrate that he has no accent. And so he wants to put on demonstrative evidence. Is it relevant? Does his absence of the accent have some tendency to prove a fact of consequence, that he's not the person? Yes. So the evidence is relevant, and the element that it's relevant to prove is identity. Obviously, identity is an element of bank robbery. Foundation is the evidence that you're offering sufficiently connected to the real events. For example, if I bring in a photograph of the scene of the car accident, well, this is connected. This photograph is sufficiently connected to the real events once I prove that this is a photograph of what happened at that car accident. If I have the picture of a flat tire, well, is this the picture of the flat tire of the car involved in that accident? If I bring a ball tire, physically bring a ball tire into the courtroom, well, this is ball tire is I have to establish that this is the very ball tire that was on the car at the time of the accident. Otherwise, it's just a ball tire. And so I have to connect up the ball tire to the real events. I have to connect up pictures to the real event. If it's a person who's going to testify about what happened at the real event, I need to ask them to lay a foundation to begin with. Were you there? Where were you at the time of the accident? For instance, I was standing on the corner of A and B Street, and it was daytime. Could you see what happened? Yes, I could see very well what happened. Now, will you tell us what happened? So first you establish that this person has personal knowledge, and when they're here before the jury, what they have to say to you is connected to the real events, because I first established that they have personal knowledge. Now, they have the personal knowledge, and we presume they have the ability to remember what they saw and articulate it to you. If the other side wants to challenge that the person doesn't have that kind of memory because it's a 3-year-old child, or the person was stoned on heroin at the time or something, then of course you can challenge that. But I'm explaining what foundation is all about. And in our case, the foundation, the evidence that's offered must be connected to the real events. Well, this one is, it's the same, it's a person that's charged with the crime, and he's saying, I don't have the accent. So we don't have a foundation problem. No exclusions. Well, we don't have a public policy issues. There's no hearsay, there are no constitutional violations. And so you just run right through the elements and show that this evidence should have been admitted because it meets the requirements. So he should have been allowed to read the newspaper article because that is appropriate demonstrative evidence. Now, the second thing that you ask is about the currency that was found in the briefcase. Dave wants to exclude the currency. Well, the currency was found by opening the briefcase, and that's a search. Okay? And the general rule application, no rule, no points. A discussion about it, useless. A discussion where you try to incorporate or include a rule of some sort, well, if you kind of get the rule in there, you might get a few points, but you will never get the high scores by doing it that way. You'll get the high scores by stating the rule and then applying it. Now, once again, once you get down to the very fine points of your analysis, you may not have time to separately state the rule and the application way down at these fine points, just because you only got an hour to do the question. When you get down to that point, you might very well include some rule and application together in the same sentence. If you do that, you make real sure that when you put them into the same sentence, that the rule stands out. Something like the so-and-so rule is satisfied because of these facts, or the rule that this must be the case, the rule is satisfied because these are the facts, something of that sort. So include the rule. Don't just kind of do it and hope that how else could you have reached this conclusion unless you knew the rule. Well, the graders aren't going to give you credit for that. Okay, you got to put the rule in there. Rule application. So the rule for searching. If you want to search something, get a warrant. That's the basic rule. If you want to search, get a warrant. Now, the police did not get a warrant. They opened the briefcase, and that was a search. You tell the bar examiners it was a search. It was a search because it invades someone's reasonable expectancy of privacy. You open somebody's briefcase, that violates their reasonable expectancy of privacy, so that's a search. Rule, wherever there's a search, basic rule, get a warrant. They did not get a warrant. If the police don't have a warrant, the rule is that the state has to prove that an exception to the warrant requirement applies. The state has to prove with the preponderance of the evidence a warrant exception. Well, here are the warrant exceptions that might apply in this situation. One, incident to a lawful arrest. Of course, we got to prove that the arrest was lawful. Inventory search, inevitable discovery, and probable cause with exigent circumstances. Those are the exceptions that we are going to try to apply. So let's take a look at those. First one, incident to a lawful arrest. Well, the argument here is that the arrest is lawful. When is an arrest lawful? Because remember, it's got to be incident to a lawful arrest. So you got to prove that the arrest was lawful. What does it take to make an arrest lawful? And the answer is an arrest is lawful if the officer has probable cause to believe a crime has been committed and this person did it. Well, the officer has probable cause to believe that a crime has been committed because the facts tell us that the police officer knew about the bank robbery. And now the question is, did the police officer have probable cause to believe that this person did it? And you now talk about the fact that this person fit the description. They were in a location apparently not that far from the bank that was robbed. They were carrying a briefcase. The tip which they received was an anonymous tip, but an anonymous tip is presumed, if it's from a citizen informant, they are presumed to be from citizens, and citizens presumably give reliable information. Now, you do run into a little bit of problem because it's possible for the police to invent these anonymous tips. They never really happened. Often they're on the police tape, so you can find out that it really happened that way. But otherwise, you're faced with the problem of, does the court really believe that this anonymous tip actually happened? And there's nothing you can do about that because you don't have any way of following that up. So assuming that the anonymous tip happened, They're presumed to be reliable. And so now the question is this tip that they received enough to create probable cause so that you have a lawful arrest? Well, you talk about what information you had, the location, and all that sort of thing. And is this enough to create probable cause to believe this is the person who committed? Well, you know, it's close. But at least it creates reasonable suspicion. At the very least, creates reasonable suspicion. Now, if the person had been carrying the sawed-off shotgun there in public, you obviously have the probable cause. But this was just a person with a briefcase that fit a description. And so, is that enough? Well, you could argue that at the very least, the police had reasonable suspicion. And the rule under Terry is that if the police have reasonable suspicion, they can stop a person and ask questions. And if they have articulatable reasons to believe the person may be armed and dangerous, then they can do a pat-down search of the person to see if they are in fact armed or dangerous. And if in doing the pat-down, if they find something that appears to be a weapon, they can reach into the pocket and pull the weapon out. In fact, if doing the pat-down, mind you, when they're doing the pat-down, I realize this was a briefcase case, but I want to convey this law to you. If the police are doing the pat-down, they are looking for weapons. They're not looking for contraband. So if in the case of doing the pat-down, the police officer gets stuck with a needle, well, you can say, hey, this person is carrying some contraband. Now they can reach in the pocket and pull that out. But if they're doing a pat-down and they encounter some object in the pocket and they don't know what this object is, okay, they cannot feel around on the outside of the pocket and think about it for a few minutes and check it carefully and so forth. No, because they are not supposed to be looking for contraband. They're looking for weapons. So the rule is that if they encounter something that may be a weapon, they can reach in and get it. If they encounter something and they don't know what it is, they cannot reach in and get it as long as they don't think it's a weapon. If you encounter something and you want to check it out further from outside of the clothing, no. Okay. Now, in this case, the police, if they had just reasonable suspicion, then they could pat down this person, and so the question is, can they look at the briefcase in the course of the pat down? Well, you know, if they believe the person may be a articulatable reason to believe the person may be armed and dangerous, then yes, they can pat down the exterior of the person. They can look in the briefcase. Now, if the briefcase is locked, they'd have to leave it alone because the person couldn't get in there to harm the officer anyway that quickly. But if the briefcase is easily and quickly openable, then they can open the briefcase and look inside. And so probably if the police had reasonable suspicion that gave them articulatable reasons, they have articulatable reason the person may be armed or dangerous because the anonymous tip said he was carrying a shotgun, and so therefore that would probably justify the opening the briefcase and finding the gun inside, finding the money inside. So the police may have had probable cause, and the search of the briefcase may have been incident to a lawful arrest, or at the very least they had reasonable suspicion with articulatable reasons to believe the person may be armed or dangerous. So in either case, then we would put lawful arrest or at least reasonable suspicion will get you into the briefcase. Next comes the inventory search and the inevitable discovery. Well, the inventory search might very well work because if you have probable cause to arrest this person, even without the shotgun, okay, if you have the probable cause to arrest the person without the shotgun, because you don't have the shotgun yet, if you have probable cause to arrest them without the shotgun, then you would have taken the briefcase to the police station with the person, and the police could have done an inventory. The briefcase wasn't locked, so they could open it and do an inventory so they could keep track of the person's property. So they would have discovered it in the inventory search if they had the reason to make the arrest, and they would have also the inevitable discovery, because they would have opened the briefcase when the person was arrested to inventory it, and they would have inevitably discovered the money then. So either the inventory, and the inventory is sort of inevitable, so they got an inevitable discovery, these kind of go together. But that's all based on your having probable cause to arrest the person without opening the briefcase. And whether or not you have enough probable cause to arrest without opening the briefcase is, you know, it's open to question. Okay. Now, next, probable cause plus exigent circumstances. If you believe the police had enough probable cause to arrest the person, okay, then the question is, do they have, and they have probable cause to arrest the person. And if they have the probable cause to arrest the person, the police have reason to believe that the briefcase may contain a shotgun, because that was their anonymous tip. And obviously this is a dangerous situation. They don't even have to go get a warrant. They don't have time to go get a warrant. And so you can call this probable cause with exigent circumstances, and that's a warrant exception. So under any of these, and you could have discussed them all, the one that's not on the board here is the Terry stop, the reasonable suspicion, and with articulatable reasons to believe the person may be armed or dangerous. Include that under here. And that's how you would deal with the currency. So I think the currency would probably be admitted on some of these theories. Next, you are asked about Dave's statement to the police officer. Well, Dave wants to exclude the statement to the police officer, and the way you would deal with excluding the statement to the police officer is either under Miranda or involuntary. Under Miranda, you recall that if a person is in custody of the police, that Miranda prohibits custodial interrogation without a waiver of their Miranda rights. Miranda prohibits custodial interrogation without a waiver. Well, do we have custody? Well, yeah, you put somebody with a gun and they're not free to leave, so you got custody. So the person's in police custody. Was there interrogation? And was there a waiver? Well, clearly there was no waiver because the rights were never given. The question is, was there interrogation? It says here, the officer said to Dave, "I know you're the one who robbed the bank. Where is the shotgun?" Well, that is interrogation. It's interrogation for two reasons. One, it asks a question, where is the shotgun? But secondly, it is, even if he hadn't said, where is the shotgun, it would be interrogation because interrogation is any statement by the police which they know or should know is likely to elicit some incriminating response. And here, if you accuse the person of the crime, "I know you're the one who robbed the bank," well, you know, that's asking for a response. You may very well get an incriminating response. So even a statement like, "I know you're the one who robbed the bank," that counts, that's interrogation. And so for both of those reasons, we have interrogation here. And there were no Miranda warnings, and so it looks like Miranda was required and was not given, unless we have an exception to Miranda requirements. One of the exceptions to the Miranda requirement is the public safety exception. This happened in a case called New York versus Quarles, where the police had pursued a person was wanted for rape, and they had pursued this person into a grocery store. And when they caught up with him in the grocery store and arrested him, he had an empty pistol shoulder holster with no pistol in it. And the police quickly said, "Where's the gun?" And the person said, "The gun is over there in the milk cartons in the grocery store." And the police went to the milk cartons and got the gun. And in that case, of course, the police did not give the person the Miranda warnings, but the court said that qualifies as a public safety exception, that the police would have been concerned that some child in the store would pick up the gun, not realize it's real, may kill somebody playing with what he thought was a play gun, and that the police had to act promptly, and this is public safety, and that's an exception to Miranda. Now, In our case, with this, the facts are almost identical. Clearly, you have a public safety exception. The gun is over there in the trash cans. And so we have Miranda was not satisfied, but we have an exception, and so it's okay. Next, the defendant may claim that the statement was involuntary. Now, an involuntary statement is defined as, well, statement's not defined as involuntary. What happens is we define voluntary, and the statement needs to be voluntary. And a voluntary statement is a statement which is made with the free and rational choice of the defendant under the totality of the circumstances. A statement is voluntary if it is the free and rational choice of the defendant under the totality of the circumstances. What circumstances do you look to for totality? Well, you look at a number of factors, such as the age of the defendant. Is it a child or an adult? The person's experience with the criminal justice system. You know, were they frightened easily because it's the first time they've ever had to deal with the police? Or this person a repeat offender who's been dealing with the police all his life? The intelligence of the defendant, whether or not the police have made promises that they can't keep, like promises of leniency when the police don't have that kind of choice. Was the person deprived of food, water, sleep over a prolonged period of time? Was the person isolated so they weren't allowed to talk to friends, neighbors, relatives for a long period of time? Did the police violate any of the person's other constitutional rights? Even a threat of disbarment has been considered as a factor in deciding whether or not the statement was the free and rational choice of the defendant under the totality of the circumstances. So in this case, the question is, was Dave's statement voluntary? We know the definition of voluntary, and in our case, the argument is that, well, there was arguably a threat because the police had a gun out when they were talking to this person, apparently still had the gun out when he asked him the question. And so, is this so threatening? Is so threatening that the person now made an involuntary statement? Is the circumstance so threatening that he made an involuntary statement? And because, you know, a person's got a gun out, you can read that to mean, if you don't tell me what I want to know, I'm going to kill you. And if so, that's very threatening. So it isn't so clear. I don't think this would be considered an involuntary statement. The gun was not pointed at the person. This was a police officer, not a stranger, a robber who says, give me your money or I'll kill you. You would believe that. But a police officer who was saying, asking some questions with a gun drawn, you wouldn't think normally that the person is going to shoot you as easily as somebody robbing you might shoot you, hopefully. And so we're looking at how threatened was this person, and we're saying it's a police officer who had the gun. It was in broad open daylight in the public. Gun was pointed at the ground. And furthermore, this person's familiar with guns. He's got a shotgun of his own. And so he's not, like, you know, scared to death by even looking at a gun. So you put all that together and you'd say, I don't think the person was unduly acting under duress. I think under the totality of the circumstances, he was probably free and voluntary under the totality of the circumstances. You can reach either conclusion you want, but argue the facts. That's the most important thing. The person also said, I knew all along that I'd be caught. And so even saying I knew all along that I'd be caught is kind of like it's a free and voluntary statement, because he sort of knew he was going to be caught anyway. It's not a big surprise to him to having been caught. So however you come out of that is not as important as arguing the facts. Argue them more very thoroughly. Finally, so I think that Miranda, we have an exception to Miranda. The statement was voluntary. And now the question is, what about the shotgun? Well, the shotgun was found as a result of Dave telling him where it was. And if if Dave telling him where it was can be suppressed, then the fruits of the poisonous tree would be suppressed also, and the shotgun itself would be suppressed. So if you believe that Dave's statement about where the shotgun is located was voluntary and did not violate Miranda, then the shotgun would not be suppressed because it is not the fruit of the poisonous tree. So the shotgun would be admitted. And that's how we would analyze this question, and that is the end of this analysis.